Greetings, esteemed audience members. I, Vijeta Kulkarni, extend my heartfelt appreciation for your presence here today. I welcome you all to the third session of our seminar, which is based on the theme of certificates and their effect. Before we move forward, I would like to thank the Hindlaw House for providing us with the barracks of Indian Succession Act. We are pleased to welcome Advocate Shriniwas Patwardhan sir as a resource person for this session. Sir is a practicing advocate in the Bombay High Court for about last 30 years. Sir has completed his BSL LLB from ILS Law College. He was the academic topper in University of Pune. Sir has also received the Best Student Award of the ILS Law College in 1994 batch of the Integrated Law course. Sir served briefly as a Class 1 officer in the Civil Services of Maharashtra before taking up law practice. His area of specialization include civil, constitutional, CPC, cooperation, arbitration, land laws, town planning laws, service laws, local laws, property laws, and succession laws. He regularly conducts lectures on civil court practice and procedure, administrative actions, judicial control of delegated legislations, civil trials and appeals, arbitration, judgment writing, and he has also delivered several lectures in ILS Law College, Pune as a resource person. He is a practicing advocate at Bombay High Court since 1995, having experience of working on more than 8,000 cases in his independent practice. Hundreds of his judgments have been reported in various reports. Sir has handled several civil and constitutional cases on the appellate and original side of the Bombay High Court. Sir has handled several cases on pro bono basis for those in need of legal service. He engaged as a junior advocate in the chambers of Y.S. Jahagirdar, Bombay High Court from 1995 to 1997. He handled numerous cases on civil side as his associate. Sir is designated an impaneled arbitrator and mediator of the Honorable High Court of Bombay. Sir is also engaged as junior advocate in the chambers of late N.P. Patwardhan sir, advocate at Pandharpur district and civil court from 1994 to 1995. I would like to invite Dr. Nilima Bhadbade ma'am to felicitate sir. Thank you ma'am, thank you sir. Before we move further, I would like to give you some brief information about our theme. Various certificates can be granted under Indian Succession Act and Bombay Regulation Act 8 of 1827. These certificates can be in the form of probate, letter of administration, succession certificates or heirship certificate, succession certificate or heirship certificate. Often question arises about the nature of these certificates. Section 211 of Indian Succession Act lays down that executor or administrator is the legal representative of the deceased and all the property vests in him as such. Section 227 of the Indian Succession Act specifies that grant of probate results into giving validity to the will and also validates all acts of executor carried from the death of the testator. Whereas as per section 220, grant of administration validates intermediate acts only to the extent they are beneficial to the estate. Section 216 reserves the power to sue only in favor of executor or administrator where grants have been obtained. Section 381 says that succession certificate shall be conclusive as against the persons owing such debts or securities and can afford full indemnity to all persons with respect to payments or dealings made in good faith in respect of such debts and securities. However, Section 385 states that a succession certificate granted under this Act is invalid if there has been a previous grant of certificate, probate or letter of administration for the deceased estate and if that previous grant is still in effect. Section 387 clarifies that a decision made under the Act regarding a question of right between parties does not prevent the same question from being tried in the subsequent suit or proceeding. It also states that a person who receives a debt or security remains liable towards the rightful owner. Also, apart from the Indian Succession Act, Section 7 of the Bombay Regulation Act 8 of 1827 pertaining to heirship certificates states that an heir, executor or administrator holding the proper certificate can perform all acts and grant deeds as a legal heir, executor or administrator and can sue and obtain judgment in that capacity. Thus, these certificates, when granted, give certain rights to the holders of the certificates, but each of these certificates differ from each other in certain details. It is necessary to understand whether these certificates are conclusive, and if yes, to what extent and to whom and against whom, whether the decisions in proceedings relating to representation can bind the parties and the world at large. While deciding the question relating to representation, questions like validity of will, its representation, legitimacy of relations may also crop up. Thus, to have clarity on the issues relating to the exact effect of these certificates, I would like to invite a speaker and resource person for this session, Advocate Shriniwas Patwardhan sir, to enlighten us.
Respected Kanetkar sir, am I audible to all? Yes. Kanetkar sir, Bhadbade madam, Andagale madam, and my dear friend and senior in the Bombay High Court, Mr. Tejas Vora. All my friends, a very good afternoon to you. I was a bit concerned. He said after having a lunch with Srikhanda and all, and especially the location issue, I am in Pune and I am in between 12 and 4. So that's the toughest time to start something. So be it. I am the disciple of Mr. Kanetkar who thrives in adversity, and I try to take a leaf out of his book and speak to you. The subject is why 4 certificates? What are they? Why different certificates? Can there not be one? I am just reformulating what has been given to me. That's correct. But before we try to find an answer to this question, what one needs to understand is how the Indian Succession Act 1925 came about. Does anybody know how many acts were consolidated to form the Indian Succession Act of 1925? We started, Dr. Barbade illustrated that the first law was the Bengal Regulations of 1799. Now that's mind-boggling, 226 years back. And there were several laws. I don't want to bore the audience by giving a very detailed list, but I'll make a mention of about 10 to 12 statutes, just the names. I'm not delving deep into it because I have very limited time at my disposal and too many things to speak about. The Succession Property Protection Act of 1841, Indian Succession Act, Parsi Intestate Succession Act of 1865, Indian Succession Act of 1865, then the Succession Certificate Act of 1889. Those were the acts relating to succession certificates of one character or the other, which were all taken together, and this final product is brought about. That's not all. There was one act of 1870 by name Hindu Wills Act. We all know that the personal law for all of us is different. The personal law for Hindus is different, Mohammedans different, Christians. Then the Succession Act very interestingly refers to one term, Indian Christians. Then Parsis, of course, different. So we have unity in diversity in that sense. The secular law is the Succession Act, which regulates everything, and the colors are filled in by the different personal laws. But mind well, the Hindu Wills Act of 1870, the Probate and Administration Act of 1881, the Probate and Administration Act of 1889, 1890, the Native Christian Administration of Estates Act 1901, and the Probate and Administration Act, the last, of 1903. They were also all merged together into this Indian Succession Act. Not only these two, there were two other laws. One was the Married Women's Property Act of 1874. Now, this was not strictly succession, but there are issues of succession arising from that act. And there is one District Delegates Act that was of the year 1881. Now, we see in the act, the Indian Succession Act, those terms, the district court and the district delegate, right? So, all these 12 acts were merged together, amalgamated into this beautiful piece of legislation that is the Indian Succession Act. Nevertheless, that is 100-year-old. So, some terms in the Indian Succession Act may sound unfamiliar, and I'll try to explain that they are not so. The language changes. Experts say every 10 to 12 years there is a substantial change in the dialect and the language. At the Act of 1925, I believe you all have the Bare Act. The first and the foremost is an attempt to answer why 4 different certificates that I tried to answer, because there are 12 acts dealing with different subjects merged into one. Those are the 4 types. Then what is the significance? What do they do? We are basically concerned with 4 of them today: heirship certificate, succession certificate, probate, and letters of administration. We will be concentrating on these. Under the Administrator General's Act also there is a certificate, but that's not the subject for today's discussion. And then there are certain other aspects of it which are kind of foreign to the discussion that we are having today. In my humble submission and the thought, the heirship certificate, which is governed under the Bombay regulations of 1827, is the most lightweight certificate of all. Please don't misunderstand when I call it lightweight. Lightweight in the sense the amount of right that it generates upon grant. You look at it from this perspective, that is the lightweight, the most lightweight certificate. Now, why do I say that? If we see sections 2 to 7 of the Bombay regulations of 1827, and the legislature is very specific. It says, in order to give confidence to third parties. The legislature doesn't say in order to give right to somebody. It says in order to give full confidence to somebody, we need to have a law, a setup which declares somebody as the heir of another. So, if I want an heirship certificate that I am the son of my father, I go to the court, make this application under the Bombay regulations of 1927, and the court, upon being satisfied that I am the son of my father, issues such certificate and stops at that. This certificate enables you guys to deal with me. My father has left a property for me. I say that I am the only son. The court has certified I want to sell the property to you. It is safe for you to buy it. Now, there are clauses which protect interests of intermediaries, etc., but details will go later on. This is the nature of certificate that the court grants under the Bombay regulations. Mind well, this is not under the Indian Succession Act. This is under the Bombay regulations of 1827. I was pondering why this act was alone left out while 12 were amalgamated. I could not get an answer. It's for you guys to do some research on, and if somebody finds the answer, I am willing to take that. Now, is what I am saying and you are hearing a perception of Advocate Shriniwas Patwardhan which the audience has to buy? No. The perception of Advocate Patwardhan flows from a judgment of our own High Court, the Bombay High Court, a celebrated judge of our court who recently retired, Justice Gautam Patel. And please note the citation, it is the case of Ankit Verma versus Vinita Verma. It is 2016, 3 Maharashtra Law Journal, page number 543. The entire judgment is worth reading. You will get to know how the High Court Registry at Bombay works or does not work, so to say, and creates unnecessary hurdles, and how a proactive judge like Justice Gautam Patel deals with them with iron hands. But please concentrate on paragraphs number 3 to 8 of this judgment, and that will explain the characteristics of an heirship certificate, in as much as it only gives a declaration that somebody is the heir of another. No civil rights flow from that declaration. That's the first kind. Second is the succession certificate. Now from here our study of Indian Succession Act would start. The succession certificate is issued by a competent court under the Indian Succession Act under section 372. Now subsection 2 of this very section sets out as to in which cases a succession certificate can be granted. We will see the subsection 1 of section 372. An application for such a certificate shall be made to the district judge by a petition signed and verified by or on behalf of the applicant in the manner prescribed by the CPC for signing and verification of the plaint. By or on behalf of the plaintiff and setting forth the following particulars: the time of the death, that has to be certain, ordinary residence of the deceased. We have heard from Tejas sir that creates jurisdiction. The family or other near relatives, the right in which the petitioner claims, the absence of impediment under section 370. Now please pause here for a minute. The absence of impediment under section 370. So let's go to 370. A succession certificate shall not be granted under this part with respect to any debt or security to which a right is required by section 212 and 213 to be established by letters of administration or probate. So there are rights arising out of succession and required to be established either through the process of obtaining letters of administration or probate, and if such rights require a letter of administration or probate, succession certificate cannot be granted. So in my submission, this is the last but one lightweight certificate. This is at a higher pedestal than the heirship certificate. Why, I will mention in a minute. But it is slightly lower in degree in terms of recognition of rights. Then why do we apply for succession certificate at all? And the answer is in subsection 2 of section 370. For the purpose of this part, security, we need succession certificate to claim a right on securities, and what those securities are, they are 5 in number. Subsection 2, any promissory note, debenture, stock or other security of the central government of state government, any bond, debenture or annuity charged by the Act of Parliament of the United Kingdom or the revenue of India, any stock or debenture of or share in a company or other incorporated institution, any debenture or other security for money issued by or on behalf of a local authority, and any other security which the state government may by notification in the official gazette declare to be a security for the purposes of this act. So these are the only securities, properties, bonds, the rights flowing out of succession in respect of these we need to take a succession certificate. A repeated mention has been made of a banker demanding a succession certificate. The reason is section 370 subsection 2. Because with the bank, you don't keep your property, right? With the bank, you don't keep your agricultural income. With the banker, you are essentially dealing with money and securities, and those are to be found in subsection 2. Now, there are other securities also as notified by the state government from time to time, but that's an issue to be debated in some other at some other time. So, succession certificate is the second kind of a certificate from which legal rights flow, but only to securities as defined under section 370 subsection 2. I hope I am clear. Heirship certificate is something that only declares your right and goes nothing further. Succession certificate gives you right qua securities mentioned in section 370. Now, what is the distinction between an heirship and succession certificate? Please don't take my word for it. We have a reported judgment of our own High Court, Justice Chandurkar's judgment in the case of Pradeep and others, and kindly note the citation. It is 2019 SCC Online Bombay 4917. Justice Chandurkar's judgment. Paragraph number 5 of this judgment, please pull out this judgment and read the full judgment. It's a small judgment, only 6 paragraphs. 5 is the longest, where His Lordship has laid down the law. And I don't propose to read the full paragraph 5, but only a small excerpt from it. His Lordship has said, a succession certificate enables the person named therein to claim a right to any security as defined by section 370 subsection 2 of the said Act. An heirship certificate is merely for the convenience of a legal heir, and it is of no consequence while seeking to establish rights to any movable or immovable property left behind by the deceased. Grant of an heirship certificate is only a formal recognition of the status of the applicant as an heir. While an heirship certificate does not confer any right to a property, a succession certificate can form the basis for claiming a right to securities named therein. That's the law for us. And then we go to the third and the fourth. We discuss them together because the Act has also treated them together at many places. And a separate mention of these two is likely to result in some confusion. So, let's take it together. Wherever it is necessary, we will deal with them together, separately. Now, before we understand what is the real effect of probate and letters of administration, we need to see one more section in the context of the discussion we had about the heirship certificate and the succession certificate. Kindly turn to section 215 of the Indian Succession Act. Let's only read the first subsection. Effect on a certificate of subsequent probate or letters of administration. Subsection 1. A grant of probate or letters of administration in respect of an estate shall be deemed to supersede any certificate previously granted under Part 10 or under the Succession Certificate Act 1889 or the Bombay Regulations number 8 of 1827 in respect of any debts or securities included in the estate. Now, Part 10 of this Act deals with succession certificates. The old Act 1889 it also makes a reference, and also makes a reference to Bombay Regulations number 8 of 1827. So, both this section covers heirship certificates, succession certificates and clearly lays down that if in respect of the very same properties there is a probate or a letters of administration, these two certificates will fade into insignificance. They will lose their value. What the parties and the law will recognize is the letters of administration or the probate, as the case may be. Now, with this in mind, let's examine what a probate or a letters of administration is. Before we actually again delve deep into it, let's go to the definition part of Indian Succession Act. Section 2. Normally, every legislation, section 2 normally is the definition. There are several exceptions, such as the Rent Act of 1999, where section 7 is definitions. Old Rent Act was 5, etc. But then this is section 2. Let's examine section 2H, and it defines will. Probate and administration essentially deals with wills. So, let's understand what the act means by a will. Will means the legal declaration of the intention of a testator with respect to his property, which he desires to be carried into effect after his death. So, I own this property. After my death, I want this property to go to the ILS Law College. It's a grant posthumous. I speak about devolution of my property, and when I say my property, my personal law also gets involved, although we will not discuss it in greater length. But under the Hindu law, my property is a separate property or a self-acquired property, and there are my properties which have inherited from top. So, the extent to which I can bequeath them under a will, the ancestral properties, etc., is a separate topic for discussion, and it will take a long time. So, we leave it at that. This is a will, and kindly presume that this is in respect of a self-acquired or a separate property, and how it has to go posthumous. Then kindly see codicil, clause B. Codicil means an instrument made in relation to a will and explaining, altering or adding to its dispositions, and shall be deemed to form a part of the will. We all write answer papers in an examination, which are normally 16 pages in length. Bright students finish it in the first hour and get a supplement. Those bright students later on, after the age of 60, Tejas Bhai has segregated those 3 segments of life. After the age of 60, when they think about their property, make a will. But 60 is the age of forgetfulness. They forget to mention some other property in the will. For that, they do a codicil. That's a supplement this bright student had borrowed from the examiner in the examination hall. Now, he is doing a codicil. So, codicil is nothing big. Please do not be frightened by this big word. There is no rocket science. It is another will. Practically, Mr. Vora has said, avoid a codicil, and I completely concur with him. But we are here to understand the concept. So, will and codicil. There are 2 more definitions. Kindly read administrator. Means a person, clause A, means a person appointed by a competent authority to administer the estate of a deceased person when there is no executor. Please mark 2 lines, 2 clusters of words. Person appointed by a competent authority, and the other cluster of words is when there is no executor. So, administrator is a gentleman who comes in absence of an executor, and the testator does not appoint him. A court, a competent authority appoints him. And understand the definition of executor in this context means a person to whom the execution of the last will of the deceased person is by the testator's appointment confided. Please mark, by testator's appointment and confided. We all heard Mr. Vora saying that this is creation of a trust. From where does the word trust come? Confided. I have a confidence in one of my friends or my brother or my wife or my daughter, one or the other, and I truly trust that they will carry into effect what my last wishes are. I confide into them the power of disposition of my property, and that creates a trust, and that is appointment of executor. So, executor is a device by the testator. He believes him. No court appoints executor. Executor is named in the will, and he carries into effect the wish of the testator. Now, we have understood the difference between heirship certificate and succession certificate, and we have slightly dealt with probate and letters of administration. Now, what is the effect? We are trying to understand what is the effect. What is the effect of appointment of an executor or an administrator? Let us all have a look at section 211. Is part of the part 8 of the Act, and it deals with character and property of executor or administrator as such. The executor or administrator, as the case may be, of a deceased person is his legal representative for all purposes, and all the property of the deceased person vests in him as such. You have understood how the rights are created in case of a probate or letters of administration. An administrator appointed or an executor named is as if the dead man is himself doing it. He gets all those powers that the dead man had in respect of his own property. The only limitation is that he has to follow the instructions of the will. If the dead man was alive, he could have dealt with his property any which way he liked. That is not available. But this is a right created in an executor or an administrator once the appointment is made. This is how the probate and the letters of administration, with or without will, different than the heirship certificate and the succession certificate. Heirship is a mere declaration of status. Succession is right in respect of notified securities, but probate and letters of administration create right in respect of whatever the dead man had and the manner in which he wants it to be disposed. And therefore, there is a statutory intent that a probate or a letter of administration will prevail over a succession certificate or an heirship certificate. Because that follows the mandate of the dead man. Whether the dead man had rights, etc., we'll deal with it separately. I hope the first of the topics that was assigned to me, the features, differences and effect of these 4 certificates is clear to you all. The effect of these certificates and the conclusiveness or inconclusiveness thereof are the 2 sides of the same coin. So, effect and conclusiveness will be dealt with together. Now, in order to understand the conclusive character of these certificates, I just mentioned at the beginning only that we had a Probate and Administration Act of 1861, which was merged into this. And section 61 of that act dealt with that. That act was bodily lifted from the 1861 act and made into 273 of the current act. Let's have a look at 273 and 275. And then I am going to show one more interesting provision, which many people in my limited experience I have seen gloss over. We have section 273 of the Indian Succession Act. Conclusiveness of probate or letters of administration. Probate or letters of administration shall have effect over all the property and estate, movable or immovable, of the deceased throughout the state in which the same is or are granted, and shall be conclusive as to the representative title against all debtors of the deceased and all persons holding property which belongs to him, and shall afford full indemnity to all debtors paying their debts and all persons delivering up such property to the person to whom such probate or letters of administration have been granted, provided that the probate and letters of administration granted by a high court or a district court, where the deceased at the time of his death had a fixed place of abode situated within the jurisdiction of such judge, and such judge certifies that value of the property and the estate affected beyond the limits of state, etc. We will not go there. So once a certificate of probate or a letters of administration is granted, it is conclusive as to his representative title. If I am the executor of somebody else's will and probate is issued, I become the owner for all practical purposes. The certificate is conclusive until revoked. Please also have a look at section 275, and this is about conclusiveness of application for probate. Mind well, these are two separate things: conclusiveness of certificate and conclusiveness of application. The application for probate or letters of administration, if made and verified in the manner hereinafter provided, shall be conclusive for the purpose of authorizing the grant of probate or administration, and no such grant shall be impeached by reason only that the testator or intestate had no fixed place of abode or no property within the district at the time of his death, unless by a proceeding to revoke the grant if obtained by a fraud upon the court. So if I properly make an application, there are no defects, the court has completely understood what my case is, the court's conscience is satisfied, procedural formalities are adopted and completed with precision, the outcome is conclusive. These are the two provisions which deal with the conclusiveness of the certificates. But then there are pundits who say that they are not conclusive. Now what do you mean by that? If section 273 and 275, which is a central legislation, declare in unequivocal words that these certificates are final and conclusive, why do some people say, or why do some judgments take a view that they are not so? First of such instances is to be found under section 391. Kindly have a look at the section 391, that's a saving provision. It's part 11. And that's the reason I said many people gloss over this. The fountainhead of the theory that these certificates cannot be binding and conclusive is 391. Let's read it. Nothing in part 8, part 9, part 10. Please mark this. Probate, letters of administration, succession certificate. Nothing shall validate any testamentary disposition which would otherwise have been invalid. So I make a will that the Taj Mahal be given to my daughter. Impossible. That doesn't belong to me in the first place. So tomorrow after me, my daughter goes and sets up a claim Oh sir, my father has executed a will, I have probated it, this is mine. Impossible. Therefore, the certificate may be conclusive as between the parties to it and against the world, but whether the disposition or the grant is good or bad can be tested independently. That is what it means when someone says that a succession certificate or a probate is not final. 2. Nothing in these parts shall invalidate any such disposition which would otherwise have been valid. The converse. 3. Deprive any person of any right of maintenance to which he would otherwise have been entitled. Now, for some, this may sound untimely or at a wrong place. What has maintenance got to do with all this? Please try to understand the mind of the legislature in the year 1925. 1925, India is a country dominated mostly by Hindu population, 80%. And the Hindu women, and I'll talk about Muslim women a minute later, Hindu women had no right to property. The Hindu Women's Right to Property Act 1937 was the first piece of legislation where there was some semblance of right given to Hindu women by a statute. All that the law provided before 1937 was the right of survival, called the right of maintenance. Now, if I make a will and I deprive some woman who doesn't have a right in any property of her bare minimum right of survival, that's murder. Now, you girls in today's world, with the 2005 amendment of the Indian Hindu Succession Act, will not understand the plight that the women went through in 1925. But the legislature was aware. So, maintenance. Maintenance cannot be deprived by a clause in the will. And the last, affect the Administrator General's Act 1913. Correct? One law cannot kill the provision of other law. Both have to be read harmoniously. Now, these are the germs of thought and judicial precedents by which it has been repeatedly said that the the probate or the letters of administration are not final, binding and conclusive. So, they are conclusive insofar as those proceedings are concerned, but whether the testator had the right, whether the grant was correct, whether it killed the right of maintenance, all this had to be considered not by the probate court. The court dealing with succession only deals with correctness of the will, whether the will is rightly executed, are there witnesses who have signed this, is the proof sufficient, will is proved, that's it. But testator did not own the property which he bequeathed, is a subject beyond the jurisdiction of a succession court, a testamentary court. And this gives rise to the concept of a certificate not being binding. Now, there is plethora of case law on this, but there are 3 judgments which I want to cite and which clearly say, in terms say, that the certificates are not binding. One is Balasaheb Pawar, a recent judgment of His Lordship Justice Modak of the Bombay High Court. It is reported in 2022, volume 2, Maharashtra Law Journal, page 85. Then another judgment of another illustrious judge of the Bombay High Court, now retired, Justice Dhanuka, Ashok Kumar Shukla's case. And the citation, it's reported at 2014, volume 2, Maharashtra Law Journal 135. There is one more judgment which I am tempted to cite. I mean, two are enough, but please note down one more. Minu, MINOO versus Shiraz. It's a 2008 3 Maharashtra Law Journal, page 542. And please read paragraphs number 16, 9 and 19 respectively of these judgments, which clearly take this view that these certificates are not final or binding. We have seen the representative character. What do we mean by that? And just to brush up the memories of you all, kindly see sections 211 to 216. Mr. Vora has taken us through that. It's part Roman 8. I don't propose to read all these provisions because we are very short on time, but kindly mark 211 to 216. The extent in law, the representative character, how the legislature defines the representative character of an administrator or the executor. Then we are also supposed to examine one more issue, finality and validity of a will. Shall we go to section 59 of the Indian Succession Act for that? It is about wills and codicils. Every person of sound mind, not being a minor, may dispose of his property by will. The only limitation is that the person should be of a sound mind and a major. Once this will happens, this is valid and final. There are other factors which render the will invalid, and that is talked of in section 61. A will or any part of a will, the making of which has been caused by fraud or coercion or by such importunity as takes away the free agency of the testator, is void. So a will is otherwise void unless it is made by a person of an unsound mind or a minor, and fraud, coercion, importunity, absence of free consent, in other words. Then in chapter 7, kindly have a look at section 112 to 118. They all deal with the validity of the will. Let's only read the marginal notes quickly because we are running out of time. Section 112, bequest to a person by a particular description who is not in existence at the testator's death. Will is not valid. Then 113, bequest to a person not in existence at testator's death subject to prior bequest. 14, rule against perpetuity. That's another recognized principle. 115, bequest to a class, some of whom may come under rules in section 113 and 114. And 116, bequest to take effect on failure of prior bequest. These are the issues which affect the finality of the will. Please also have a look at section 126. That's in chapter 11. Bequest upon impossible condition. Like I bequeath the Taj Mahal to my daughter. And 127, bequest upon illegal or immoral condition. I bequeath to my son a sum of 10 lakhs of rupees if he murders Mr. X. My son is not expected by law to murder Mr. X. This is a void bequest. We will also briefly turn to section 35 of the Bharatiya Saksha Adhiniyam. That's a topic for discussion. Shall we have that? I mean, the law is completely the opposite except section 35. Indian Evidence Act, section 41. All right. I'll read section 35. It's a small section and very easy to understand. This section 35 is part of a topic which says the judgments of the court when relevant. And 35 is relevancy of certain judgments in probate, etc. A final judgment, order or decree of a competent court or tribunal in the exercise of probate, matrimonial, admiralty, insolvency will omit, which confers upon or takes away from any person any legal character, like an administrator is appointed or removed, or which declares any person to be entitled to any such character or be entitled for any specific thing, not as against any specified person, but absolutely is relevant when the existence of such legal character or the title of any such person to any such thing is relevant. So, all judgments of courts are relevant facts, but they are subjected to strict proof, except this. And why do I say that? Please read subsection 2. Please listen to subsection 2. Such judgment, order or decree is conclusive proof. A probate judgment is a conclusive proof that any legal character which it confers accrued at the time when such judgment, order or decree came into operation. 2. Any legal character to which it declares any such person to be entitled accrued to that person at the time when such judgment, order or decree declares it to have accrued. 3. Any legal character which it takes away from such person ceased at the time from which such judgment, order or decree declared that it has ceased. And anything to which it declares any person to be so entitled was the property of that person at the time from which such judgment, order or decree declares that it had been or should be his property. Probate declaration is conclusive. We have read provisions in the Indian Succession Act which deal with conclusiveness of probate and letters of administration. Section 35 of the Saksha Adhiniyam deserves a special mention. It not only makes that previous judgment in probate proceeding or letters of administration proceeding relevant, but it says they are conclusive. In other words, nobody can say that it declares some right illegally, unauthorizedly, incorrectly. The remedy is apply for revocation. How does one do that? Is for my Guru, Mr. Kanetkar sir, to deal with in the afternoon. But section 35 of Saksha Adhiniyam is therefore relevant. Now we have also talked about, and Mr. Vora took us through great detail about the wills, and Madam also, about the wills executed within the Bombay city, Mumbai city, that is the metro cities, Mumbai, Kolkata and Chennai, formerly Bombay, Kolkata and Madras. And the necessity of probate, section 213. Nobody can establish, nobody can stand up in the court and say that no, I am the executor, if it goes to the court. If it is outside the court, me and my brother are having a peaceful life and we don't dispute the will left by my father or my grandfather, no court will come and poke you. Mr. Where is the probate? But all this starts when there is a dispute. So the dispute starts, the will is in respect of a property in Mumbai or of a property outside Mumbai but made at Mumbai. Will is made at Mumbai. Probate is compulsory. We have seen section 213. We have also seen that properties not falling within the metropolitan areas of Bombay, Mumbai, probate is not compulsory, although it is advisable to secure and to clearly highlight the rights of the parties qua the property bequeathed to them. But it is not compulsory. I will not dilate much into this distinction, but there is one beautiful judgment of the Supreme Court. Kindly note the citation. It is a case of Ravindranath Agarwal. And mind well, this is a judgment of a single judge. Supreme Court never sits as a single judge, except when these are the cases of transfer of proceedings. The Supreme Court rules are modified now. So where a case is to be transferred under section 24 of the CPC from one state to another, Maharashtra case has to go to Madhya Pradesh or to Rajasthan. Neither the Maharashtra nor the Madhya Pradesh court will have jurisdiction. The case straight goes to the Supreme Court. And the Supreme Court used to sit in 2 or 3 judges' strength and hear it. Supreme Court said these are issues that can be dealt with by a single judge. So a single judge deals with this transfer case, but deals with the distinction between how one should go about in case of wills within metropolitan areas and outside. A very beautifully written judgment where the learned single judge had in no uncertain terms has said that 2 judgments of the Supreme Court of the bench strength of 2 and 3 respectively. Mind well, 2 judges or 3 judges will bind a single judge, but this single judge says they don't decide the law correctly. And in my humble opinion, the learned single judge is right. Academically, who is right, who is wrong is for everyone else to fathom, count and decide. Please see Ravindranath Agarwal, not only for the beauty of the judgment but also for the courage of a single judge. 2021 volume 15 Supreme Court cases 282 SCC 282. That's one issue, very interesting, although it is out of syllabus for me, but I thought since nobody has touched, I ventured a bit out of my line of operation, as has Justice Ramabhadran of the Honorable Supreme Court. But there is one more topic which is balance and which is in my syllabus, and that is about the character of a judgment which issues a probate or a letter of administration, that is whether that judgment is in rem or is in personam. Now we have heard plenty of pearls of wisdom from Mr. Vora and Madam. The judgments are judgment in rem. They operate against the whole world. They are normally A versus B, but they do not bind only A and B. They will bind C, D, E, F till Z and infinity, because they are judgments in rem. And that is the precise reason why courts have repeatedly said that under the Arbitration Act you can't decide the disputes about probate, and because they are not disputes between the parties. Arbitration are disputes arising out of contract. This is not a contract. Will is not a contract between the testator and the beneficiary. So that's another issue, although, but these are all judgments in rem, and I have found 3 beautiful judgments which have taken that view. One is a 3-judge bench of the Supreme Court, a recent judgment of Ramesh Bhagwat, we heard a mention about Lodha versus Birla in the morning. That is a very famous case. I hope most of you are aware. Birlas are a big industry house, very rich people. Has anybody not heard about Mr. Birla's industry or house? Anybody who does not know the name Birla? No, Birla is a known family, big industrialists. Many of them were freedom fighters. In their estate, there was a dispute. A lady, will not take names, made a will and bequeathed property to her chartered accountant. That is Mr. Lodha. And therefore, the judgment is Lodha versus Birla. Please read that judgment. Funny story and beautiful piece of precedent. That is also taken into account in Ramesh Bhagwat's case and Justice Misra's judgment. This Ramesh Bhagwat, kindly note down the citation, 2020, volume 17, Supreme Court cases 284. And the issue of whether the judgment in succession cases is in rem or personam is dealt with in para 15 and 16. But please read the full judgment also. I am just giving the paragraph numbers to do some rapid reading and digest what I am saying, but I expect you to digest more than what I am saying. Actually, my job is not to tutor you or to give you gyan, as the young generation now says. My job is to stimulate the thought inside your head, and that I hope I am doing. Another judgment of another three judge, the Bombay High Court judgment, Justice Mohit Shah headed that division bench. I guess it was Justice Sanklecha who was the junior judge, both exceptional judges, Neena Agarwala, and that is reported in 2013 for Maharashtra Law Journal 464. Paragraph 13 of this judgment, as I have repeatedly said, for your rapid reading, I expect that you should read the full judgment. Then there was a very beautiful issue. A judgment, we always know that it operates in rem. What operates in rem means what? If there is an offence, a criminal court is seized of the matter. Is the criminal court also bound by it? Does it operate in a criminal proceeding also as a judgment in rem? The answer is the Supreme Court has answered in the affirmative. Kindly note down the judgment. It is Syed Aksari, SYED AKSARI, Syed Aksari versus State. Authored by His Lordship Justice S.B. Sinha, one of the best in business, retired now. And the view is that a judgment in rem will also bind a criminal, a court sitting in criminal jurisdiction. Para 32 of this judgment, this is about 4 or 5 lines in this paragraph. Please read the full judgment. It's a beautifully written masterpiece. But para 32, the Supreme Court has clearly said that even a criminal court will have to take this in account because this is a judgment in rem. This angle I thought was not covered, so I thought it to bring it. Citation? Sorry. 2009, 5 SCC 528. Paragraph number 32. Made a request to Badbade ma'am. This concept of succession law, we are all basically from urban areas, I believe. Very few of us from rural areas, where cooperative housing society is the fashion, or it's in vogue. I mean, we occupy flats in cooperative housing societies. And just see how the cooperative societies legislation has taken into account this succession laws. Please see, you may not be having that. Section 154B. One second. Capital B. It is chapter Roman 13 capital B and section 154 capital B hyphen 13 13. Transfer of, I'll read it because this was not part of what we had planned to discuss. Transfer of interest on death of a member. That's the provision in cooperative housing societies. On death of a member of a society, the society shall transfer share, right, title and interest in the property of the deceased member in the society to a person or persons on the basis of testamentary documents or succession certificate or legal heirship certificate or document of family arrangement executed by persons who are entitled to inherit the property of the deceased member or to a person duly nominated in accordance with these rules. So the rules of succession in a cooperative housing society are now formally recognized by a state legislation. That's what I wanted to highlight. But in the process, I have accidentally highlighted the poverty of drafting skills, because the draftsman says testamentary documents or succession certificate or legal heirship certificate or documents of family arrangement and forgets to mention about the most important documents, probate or letters of administration. So be it. But this is a provision which I thought deserved a mention. So thank you, madam. Thank you so much. Thank you.
Thank you so much for your insightful presentation, sir. The things we learned here are definitely very helpful for us. Now we will immediately be starting with the next session, and I call upon Ms. Srushti to take over.